Since your topic for today is Workmen's Compensation Act 1923. So the objective behind this act was it aims to provide the workmen and or their dependents some relief in case of the accidents that arise out of and in the course of their employment, causing either death or disablement of those workmen. So this is a kind of protection given to these workmen during the course of their employment that arise out of and in the course of their employment. Now the scope and the coverage. So this act extends to the whole of the India. The workmen whose occupation is hazardous should be included within the scope of this act. It applies to the workmen employed in factories, mines, plantations, transport establishments, construction work, railways, ships, circuses, and other hazardous occupations and employments that are specified in the Schedule 2 of the Act. So, Schedule 2 is specifying all these uh, workmen's work, whatever, like some of the examples are written here. Now, the act does not apply to members of armed forces of the union and those workers who are insured under the Employees State Insurance Act 1948. So, these are the ones on which this act does not apply. Now, the coverage of this act is also to cooks who are employed in hotels and restaurants. So here are the certain definitions that are mentioned and stated in section 2 of the Workmen's Compensation Act 1923. So the first one is dependent. Who is a dependent? So section 2 clause 1 subclause D uh, states dependent, meaning of dependent. So dependent means any of the following relatives of the deceased workman. So there is a deceased workman and following people will be that deceased workman's dependent. First, a widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, or a widowed mother. Second, if wholly dependent on the earnings of the workman at the time of his death, a son or a daughter who has attained the age of 18 years who is infirm. Third, any of the following were wholly or partially dependent on the workman at the time of his death: a widower, a parent other than a widowed mother, a minor illegitimate son, a unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if married, and a minor of its widowed and minor. Then a minor brother or an unmarried sister or a widowed sister if a minor, a widowed daughter in law, a minor child of a predeceased son and daughter where no parent of the child is alive, and a paternal grandparent if not the parent of the workman is alive. Now, in section 2, clause 1, subclause E, definition of employer is given. So, who all are employers? So, employer includes any person or body of persons, whether incorporated or not, any managing agent of an employer, the legal representative of a deceased employer, a person to whom services of a workman are temporarily lent or let on hire. So these are the people who will be employer. Now, section 2, clause 1, subclause N explains the definition of workman. So, a workman is any person who is a railway servant as defined in clause 34 of section 2 of the Railways Act 1989, who is not permanently employed in any administrative, district, or subdivisional officer of a railway and not employed in any such capacity as it is specified in Schedule 2, a master, seaman, or other members of the crew of a ship, etc. It does not include a person whose employed is of casual nature. A captain or other member of the crew on an aircraft, a person recruited as driver, helper, mechanic, cleaner, or in any other capacity in connection with the motor vehicle, a person recruited for work abroad by company as is mentioned in Schedule 2. So, now persons to be treated as workmen. There must be a contract of employment so that the person is treated as a workman. There must be a relationship of master and servant between the employer and the employee. Third, the employment is for the purpose of employer's trade or business. Now we will discuss about disablement. So disablement means reduction in earning capacity. So this in this the person is disabled from earning what he could earn before getting disabled. So it is of two kinds: partial disablement and or total disablement. So in partial disablement there is a temporary partial disablement or permanent partial disablement, and in total disablement again it is temporarily or permanent. So temporarily partial disablement means that which reduces the earning capacity of the workman in the employment in which he was engaged at the time of the accident. So, in this, the workman's capacity to earn money is reduced in the employment in which he was engaged at the time of the accident. Second is permanent partial disablement. This means that which reduces for all time the earning capacity of a workman in every employment in which he was capable of undertaking at that time. So in this, his workman's earning capacity is reduced in every employment in which he was capable to take to undergo employment to undertake an employment at that time. Now third is the total disablement. So in total disablement, whether it is a temporary one or a permanent nature, which incapacitates a workman for all work which he was capable of performing at the time of the accident. Now, how is the calculation of compensation done? In case of death, amount of compensation is equals to 50% of the monthly wages into relevant factor or rupees 80,000, whichever is more. In case of permanent total disablement, amount of compensation is 60% of monthly wages and relevant factor or 90,000 more, whichever is more. In case of permanent partial disablement, amount of compensation is 60% of the monthly wages into relevant factor. In case of temporarily disablement, amount of compensation is 25% of monthly wages. So when it is about total disablement, the compensation amount has increased than the partial disablement. Thank you so much.